Hello and welcome to another A Level Law video. This one is on one of the general defences. I teach AQA A Level Law. This is on paper 1, and this is the defence of self-defence or lawful force. So the objective to this, of course, if this was a normal session, would be to understand the defence of lawful force or self-defence, to explain the test paying attention to both the subjective and objective elements, to appreciate the limitation on when the defence can be used or excessive force can be used, to understand the implications of an honest mistake, and of course you would apply this to a problem question. Now, just a tip and note, in the exam this might be a little hard to spot or not as easy to spot. You need to look carefully about whether someone is responding to someone else's provocation and they react in some way. So the three things we're going to look at, there is one more thing which we'll deal with at the end about householders, but this is about, we're going to introduce what is, we're going to look at the common law defence and the statutory defence. And we'll begin with an introduction to what lawful force is. Now, lawful force then covers a range of situations where a defendant is allowed by law to use a reasonable amount of force. Now, a common law, which is partially consolidated by a statute, it is lawful to use such force as is reasonable in the circumstances to either defend yourself, which of course would be self-defence, or anyone else, to make a lawful arrest, to prevent a crime, to protect property, to evict a trespasser who refuses to leave, or certainly within England and Welsh law, by a parent to discipline a child. Now, when a defendant wishes to raise the defence, there must be enough evidence before the court on which a reasonable jury might think it was reasonably possible that the defendant was acting in self-defence. So it is up to the jury to decide, as we know. Where there's such evidence, the question of whether the defence must be left to the jury. Now, the defence can be used for all crimes and is a full defence. Now, of course, for AQA law or other A-level law, it's going to be for a violent offence. Now, essentially, the defence makes one's actions lawful, and there's a common law as well, a private defence, and then a public defence, which is under Section 3 of the Criminal Law Act 1967. We'll deal with each of these separately. First of all, then, we're going to look at the common law defence, and essentially there are two key elements, or two kind of key structure elements for you. And this is did the defendant honestly believe force was necessary? So the subjective test, and is the amount of force necessary, which is sort of at least an objective test. I'm going to deal with this one first. So did the defendant honestly believe force was necessary? Now, the thing to say about this then is, it's not really whether force was necessary. In most circumstances in your exam, the force is going to be necessary, and that's obvious in any situation. So the normal thing you would do is explain why force was necessary, the reason they used the force, and of course then move on to some of these exclusion or inclusion matters, such as whether a preemptive strike is allowable. So you're allowed to strike first before being hit, whether a defendant has a duty to retreat, whether there was a mistake about whether force was needed, whether it's retaliation or revenge, or if the defendant begins this situation as the aggressor. So as ever, we're going to look at the first one first, and this is the preemptive strike. Is this allowable? And they are allowable. You know, if the defendant hit the victim first as he was under attack, or honestly thought he was under attack. Now, that's the most obvious situation, but there are certain cases, such as the Attorney General's reference number 2 of 1983, in which it was not necessarily a personal attack, but attack to property, and it was lawful to preemptively do things which potentially would be illegal, but certainly falls within this category. So in this case, the defendant's shop had been attacked and damaged by rioters, and he was fearing further attacks, so he made petrol bombs and kept them ready to defend his property. Now, he was charged with possessing an explosive substance contrary to the Explosive Substances Act of 1883. Of course, this preemptive strike, this creation of the petrol bombs, he pleaded self-defence and he was acquitted, and this decision was upheld by the Court of Appeal. And the second one then is whether a defendant has a duty to retreat. Do they have to retreat? Now, they don't. They don't have to retreat, or to escape from a situation. A person has a right to defend oneself. Now, this is clear in both common law and under the Section 76, subsection 6, A of the Criminal Justice and Immigration Act of 2008, which has updated the law on self-defense and lawful force. Now, the case of Bird is a good example of this. In this case, there was an argument between the appellant and her ex-boyfriend, who had a bit of a heated argument when he ended up with a new girlfriend. Now, he left the event, came back, and there was a bit of argument again. Now, he slapped her and pinned her against the wall, and the appellant punched him in the face and forgotten that she had a glass in her hand. And this glass broke, causing Marder to lose his eye, the attacker in the situation. And she was charged with wounding under Section 20 of the Offence Against a Person Act 1861, and she argued she acted in self-defence. Now, the trial judge directed the jury that in order to rely on self-defence, the defendant must demonstrate that she didn't want to fight. Now, the jury convicted her, and she appealed, contended there was no obligation to demonstrate an unwillingness to fight. And this ground of appeal was accurate. The conviction was quashed, and whilst withdrawing or demonstrating an unwillingness to fight is good evidence the defendant is acting in good faith or reasonably, there's no obligation, so this is proven by this case. And so what we got next is mistake. So what if the defendant has made a mistake in terms of whether they were allowed to use force? Now, the trick here is the belief is that they would need to act in self-defense is a subjective test. Now, what must be proven then is that the defendant must honestly believe that he was in danger and it was necessary to defend himself. It doesn't matter if the mistake was, in this belief was mistaken or unreasonable. It just has to be genuinely held and honestly believed. So a good case example is Williams or Gladstone Williams, in which a man saw a woman become a victim of a robbery by a youth. Now, he struggled with the robber to stop him and hand him to the police. Now, the defendant saw the struggle and presumed that the youth, who was the robber, was the victim of an assault by an older gentleman, and he stepped in to protect him. Now, the man successfully upheld his defence as he genuinely believed he was preventing a crime. Now, there was an honest mistake here, and it's sufficient as the defendant jumped off a bus to hit the victim, who was in fact trying to detain the thief. So there was an honestly held belief, so this element would be satisfied. In Beckford and the Queen, so this is a case from Jamaica, and this is a Commonwealth decision. A policeman here who shot a man who had been terrorising his family was able to use the defensive mistake when he wrongly believed, as it transpired, the victim was armed. He thought he was armed, but he wasn't. Now, of course, as a practical matter here, the more unreasonable a defendant's claim mistake is, the less likely a jury is to believe the mistake. So we just have to, in that situation, ensure a jury believes it. And then we got Palmer, in which the defendant and two others were chased by a group of three men from whom they stolen some marijuana. Now, the three men who were chasing the defendants had sticks and stones, but the defendants fired gunshots. Now, one of the three men died as a result of the gunshots, and the defendant was found guilty of murder but appealed under self-defence. And the court decided the force wasn't reasonable, but for this point, some force was necessary. It was disproportionate, which we'll come to shortly. Now, we'll come to this again, but Section 76, subsection 3 of the Criminal Justice and Immigration Act 2008 provides a question about whether reasonableness is excessive. Now, again, we'll come to this later on, but if a defendant has grounds to believe, it doesn't matter if it's a mistake. And so really the point we're using this is this idea of a mistake is acceptable so long as the defendant genuinely believes in a situation that they're allowed to use force. Now, if it's a drunken or intoxicated mistake, you'll find a pattern here when you study criminal law. Often, if the defendant is intoxicated, it has a negative effect on most defences. If you think it's diminished responsibility, for example, if you're just drunk, you won't be able to use that defence. Even to insanity and automatism, you won't be able to use those defences generally if you are intoxicated. Now, in O'Grady, the defendant made a intoxicated mistake here about the amount of force to be used, and in using a glass ashtray to hit his friend when he fell asleep and woke up to be being attacked. And when he used this, it was unable to use a defence because of the intoxicated mistake about the amount of force that were going to be used. And then Lippman, another famous case, the appellant here was taking some LSD. He was hallucinating and believed to be attacked by snakes and descending to the centre of the earth. In his state, he killed a girl by cramming bedsheets into her mouth. Now, his intoxication here could be used to demonstrate that he lacked the mens rea for murder, but he was under a mistaken belief that he was being attacked by snakes, induced by an intoxicated state, and therefore could not use the defence of self-defence. Now, slightly linked to this then is, what about if the mistake is because of delusions? Now, you'll find this case of Soy Nyoi, which is otherwise known as Oi, and this was about a defendant who attacked police officers in a coffee shop as he felt rushed to do it as he was being threatened by evil spirits. He felt he was defending himself. Now, the defence of insanity failed as the jury rejected it, and self-defence was also raised. But for policy reasons, it was held in this case that the more insanely deluded a person is, the less likely he should be able to use self-defence. So that's certainly the point we should be taking. Of course, if somebody's retaliating or revenge, we see a pattern through criminal law is that they must feel attacked under the time. It must be an active threat at the time. And as the defendant must feel threatened or be under attack at the time of the defensive conduct, the defence will not be available if the force is used after all the danger is over. So if it's a retaliation or revenge, so the defence will not be available. A good case example here is Hussein and another, where the defendant's house was broken into and he and his family were threatened by armed men. The defendant and one of his sons managed to escape and chase the armed men as they ran from the house. They caught up with one of the men and beat him up. It was held that they could not use the self-defence as all the danger was over, from the original attack was over, so essentially the danger had passed, and so therefore they were not able to use it because it was now retaliation or revenge. And finally, what if then the defendant is the aggressor? So this is, in school terms, he started it. So what we got is, a good case of Rashford, which the defendant here sought out the victim or tried to find him, intended to attack him in revenge for an earlier dispute. Now, the victim and his friends reacted out of proportion to the initial aggression from Rashford. He then switched from aggression to defence. Now, in discussion of this case, the judge decided the defendant cannot use the defence as the aggressor throughout the whole situation, or he cannot use it. The only way you could use it if you're trying to escape. So if you begin as the attacker, and then you switch to defence, and you use aggression trying to escape the situation, then you can use the defence. But if you just stay as the aggressor throughout the whole situation, you will not be able to use it. And so a trick here is when you're doing the exam, you obviously won't have all of these. You need to pick out these as a sort of mental checklist. If you spot a preemptive strike, then you need to discuss that. If you spotted that the defendant doesn't have a duty to retreat, or they're trying to escape or didn't escape or stayed and fought, then you should raise this. If there's a mistake, so the defendant got it wrong, they still can use defence, but then consider, are they deluded or suffering from delusions, or are they drunk? And of course, if they started the situation or it's retaliation or revenge, that might come up too. Usually, it's only one or two of these. Just make sure you pick out the accurate one, discuss it, analyse it, apply it, and so on. Now, the second question then is the amount of force necessary? So, okay, we've accepted that some force was okay to use, but we need to go into this depth of, is it necessary? Is the amount of force necessary? Now, this is arguably the objective element of the test, but we do take into account the circumstances, so it's not entirely objective. It's objective in that situation. So what would the person do in that situation with the characteristics of the defendant, for example, or in the situation they found themselves in? And again, this is a question for the jury to decide. Now, in White in 1987, the judge, Lord Lane, said it's necessary and desirable that the jury be reminded of the defendant's state of mind at the time of the incident. So if they're frightened, panicking, acting instinctively, then you need to take that into account. So it is not purely objective. And this can impact the decision of the jury, of course. So therefore, although the question of force was reasonable as a matter to be decided by the jury, it's critical that in judging the reasonableness, the jurors put themselves in the circumstances that the defendant believed them to be. Now, the test is therefore not completely objective, as there is a subjective element. This should allow the jury then to take into account the fact the defendant may only have a split second in which to react to a threat and may not be able to consider his response. So it's been codified, by Section 76 subsection 6 of the Criminal Justice and Immigration Act of 2008. Now, except in householder cases, force which is disproportionate is considered unreasonable and the defence will fail. Now, it's largely objective, as we've seen in Soignoy, and invites consideration of a balance between the risk of harm to the defendant and the victim, but takes into account, so there's no simple reckoning of equality. So, for example, fist versus fist, you may need a weapon. If you consider a young person against an older person or a stronger person, they may need to match up that use of force, They need to use a weapon, for example. Now, sometimes initial proportion of force may become disproportionate. So if you kick somebody, but you repeatedly kick them, then this may become excessive. So Section 76, Section 3 of the Criminal Justice and Immigration Act states it must be considered what force the defendant considered was reasonable at the time. So we need to make sure this is a little bit more subjective. The jury will be directed on this. And Section 76, Subsection 7 calls for a balance, really. It states a person acting for a legitimate purpose may not be able to weigh to a nicety the exact measure of any necessary action. So good phrase to use, a weigh to a nicety. They don't have to pick the exact measure. They don't have to say an eye for an eye, or punch for a punch, kick for a kick. They are directed, the jury are directed as to consider it doesn't have to be exactly proportionate. It just has to be reasonable. So a good case example to use then is Martin, one which you've doubtless seen before, surely when you studied murder, for example. And this one is a case in which a farmer was burgled, and as the people were leaving, he shot one of them in the back, killing him. Now, he did have paranoid personality disorder and raise other defences, but his appeal here was rejected by the Court of Appeal in terms of the self-defence element, because he didn't take into account self-defence. He didn't consider the self-defence. As conviction was reduced to diminished responsibility, but the reason this failed was, of course, because where defenders shot at intruders as they ran away, lawful force failed, so the defence was disproportionate. Shooting someone who's away, the danger's already passed, so the amount of force in that case was not necessary. And another good case example is the case of Clegg. So he was a soldier on duty in Northern Ireland. As a car came towards him at the checkpoint he was manning and sped up with his headlights on, one of the soldiers with Clegg shouted for the car to stop, and it didn't. Clegg fired 3 shots at the car and a further shot as the car passed him. Now, the final shot as the car passed killed a passenger in the back of the car. And Clegg couldn't use self-defence, as the defence's evidence showed that the car had gone past him at the time he fired was the last shot, so there was no danger. So again, in this force here was excessive. They couldn't use the defence. Now again, what we need to consider is this idea of mistaken belief in the amount of force. We looked at this in the context of whether mistaken belief as to whether force should be used, but now we're considering this idea of, is force disproportionate because of a drunken mistake about the amount of force needed? And Hatton again is a good example, where he beat the deceased to death with a sledgehammer after drinking over 20 pints of beer. Now, his recollection of events was unclear, but he believed he was under attack. The issue is about the reasonableness of the defendant's reaction, as he believed the facts to be. Now, even if that belief was mistaken and the mistake was caused by intoxication, now, it was held that in self-defence, a mistake as to the amount of force used, which is a mistake induced by drunkenness, cannot be relied upon. So generally in your exam, you're going to be looking at the common law defence. If there's some sort of attack on a person and they react, that's self-defence. But there is, of course, a statutory defence as well, which was established by Section 3 of the Criminal Law Act in 1967. And this is known as a public defence. Now, what Section 3 tells us is a person may use such force as is reasonable in the circumstances in the prevention of a crime, or in effecting or assisting in the lawful arrest of offenders or suspected offenders, or of any persons unlawfully at large. So reasonable force then can be used in the prevention of a crime or making an arrest to allow a person to defend themselves from a criminal attack, prevent an attack on another person, or to defend their property. Now this test then is objective. Now there is some overlap between the two then of the statutory and common law defences, in that acting in the prevention of a crime would embrace most situations covered in the common law defence. So for you as a student, you certainly should cover the common law defence in an exam. Now in many cases of assault, the statutory defence then is also available to the defendant in addition to the common law defence of self-defence. Now the authority for this is the case of Cousins, which tells us that both defences can be used in conjunction with the other. And so that completes the main body of this particular section. But of course, what you need to do is consider householders as well. So householders can use disproportionate force. However, of course, this for AQA would sort of be with a situation with burglary. So I'm not covering it in this video because quite simply they're not going to be put in the exam a burglary situation, because that might confuse some students and start to consider any offences somebody commits when they go into a house. Unlikely to come up on the AQA, so for that reason I'm not covering it. But yeah, thanks for listening. So this is Reasonable Dan on YouTube. Also TikTok videos available, go and check that out too. Thanks.